Frankie, I think it's good to go.
Yes, sir.
I'd just like to say welcome to everybody, all the participants to the AORC webinar, the first one of 2023. I have to say I'm very impressed that the AORC team have hit the ground running, getting something together that's this good, this quickly, and this early in the year. So it certainly means that 2023 promises to be an exciting year. I'd like to commend them for their hard work that goes into organizing this ongoing series of webinars. I think it's one of the most successful in the field, and it is unique across this entire continent. And they've managed to pull it off in what are often quite difficult and cash-strapped circumstances. So congratulations to the team, and my heartfelt thanks to you for keeping the flag flying and doing this good work. The law school is very, very, very proud to be associated with you guys. I see it as a collaborative arrangement. It's not that we host you, it's that we work together. The invitation notes that some complaints of injustice are caused by maladministration against government departments, and that they cannot be turned into legal action because they may be too trivial for the courts. I think that we need to look at that, and I think we need to add to that sometimes even non-trivial complaints are often not turned into legal action, as access to courts from multiplicity of reasons, not least of which is the high cost, is neither easy nor universal. And so alternative dispute resolution thus becomes doubly important. Not only, from a quote from the invitation, is it a safe forum, but often it is quite often the only affordable forum that is available to some people. As a former legal practitioner who specialized in civil litigation, I'm all too acutely aware of the minuscule percentage of disputes that actually go to court, and of the even smaller percentage that are successfully resolved. And so for that reason, I'm very, very pleased to welcome our speakers who are sharing their time and expertise with us today. Now, there's a quick proviso here and a sort of a service announcement. My apologies in advance for my poor pronunciation. But firstly, Mr. Chijikoki Nana Ibeku, who is the founder and principal partner of 3C's Met International Institute of Mediation, Negotiation, Counseling, and Conciliation, in one breath, from Nigeria, who will be speaking to us about the value and guidelines for interest-based negotiation in resolving disputes. And we then also have joining us from Argentina, the Honorable Gabriel Savino, who's the Ombudsman of Santa Fe, who will be speaking to us about the value and guidelines of mediation as a means of resolving disputes, as well as the work and the tasks of the Ombudsman of Santa Fe's mediation unit. Mr. Chidi Martins Lasbury, the former Vice President in charge of marketing and membership drive of the Institute of Chartered Mediators and Conciliators of Nigeria, will be speaking to us about the value and guidelines for conciliation as a means of resolving disputes. It's not something that lawyers hear every day. This will all take place in the safe hands of Mrs. Kurai Makumbe, who's the Chief Human Rights Officer, Complaint Handling and Investigations. She's here today on behalf of the Honorable Commissioner Elasto Mugwadi, who's the Chairman of the Human Rights Commission, Zimbabwe. So all I have left to say is, again, welcome on behalf of the School of Law at the University of KwaZulu-Natal, and to everyone here, please enjoy. Thank you very much.
Thank you very much, Adrian, for that. This is much appreciated for that introduction. As highlighted, good day, distinguished ladies and gentlemen. I am pleased to be facilitating this workshop, this webinar on behalf of Commissioner Dr. Elasto Hilarious Mugwadi, who is our chairperson of the Zimbabwe Human Rights Commission. Dr. Mugwadi sends his regards and apologies for not being able to join us today.
Ms. Makumbe,
yes.
Ms. Makumbe, before you proceed, can we allow the APP advocate Koleka Galeka to give a welcoming, and then you will take over to facilitate. Yes.
Oh, yes.
Welcome,
okay.
APP.
Yes.
Thank you. A very good morning once more. Thank you, Program Director. Thank you, Frankie. Allow me to acknowledge Mr. Adrian Belengue and the UKZN family, Honorable Commissioner Elasto Mugwadi, Mr. Chioke Nana Ibeku, Honorable Gabriel Savino, Mr. Cindy Martins Lasprey, the AOC team, who forever never disappoint indeed. Audience who are joining us online from the Republic of South Africa, but also from the other ombudsmen in other jurisdictions in the world. Allow me to welcome you into this first webinar in 2023. We're hoping that this year brings us all good and blessings, particularly as ombudsmen, as we continue to serve our countries with distinction and pride. Now, touching on this very important and critical topic, particularly for ordinary masses within our societies, for whom ombudsmen are established for, particularly that there is no payment required to approach an ombudsman. There is no rigid process involved that the ombudsman uses. So it is for the understanding, particularly of the layman, the illiterate, the poorest of the poor, particularly in regions such as South Africa at large. Now, ombudsmen are institutions which have become a common feature that most countries utilize within our frameworks in the variety of our mandates, from accepting and dealing with complaints against the public administration to safeguarding the human rights of their citizenry. The Ombudsman is an institution that belongs to the category of informal justice per se processes intended to address complaints from individuals and act to investigate, review, and address individual or systemic violations of maladministration, while at times may overlap and distinct from the relief sought through the implementation of justice in our courts. Many of us members and leaders in our respective institutions may find it obvious, but for the benefit of the audience, some of whom may be ordinary members of the public, find it necessary to touch on but a few of the benefits provided by mediation and alternative dispute resolution in its generality, prior to linking it directly with ombuds institutions. The most appetizing benefit of mediation, I would imagine, it is the cost saved by the parties, but also that some parties do not even have the resources. Mediation in all its forms is ordinarily cheaper than the process of adversarial litigation. Furthermore, it is ordinarily quicker than the courts or arbitration processes. And of course, the hallmark of mediation and alternative dispute resolution is that it makes or places the decision-making power on the outcome of the process in the hands of the parties themselves. Ombudsman institutions trying to resolve problems and mitigate the harm caused to people's rights rather than conducting full-scale investigations. This allows for the redirection of the resources involved in extensive investigative processes to be utilized in the resolution of identified problems. Mediation and alternative dispute resolution allows for this because it can be utilized in a wide range of disputes so long as the parties are willing to share their needs and want the mediator or the arbitrator who is there to guide them, who also must be impartial in the process. Ombudsman institutions have increasingly used specific ADR techniques such as conciliation and mediation to handle complaints. In essence, the parties to a conflict engage in a voluntary collaborative process in which they identify issues develop options, consider alternatives, and develop a consensual agreement under the guidance and direction of the Ombudsman. Formal mediation is entered into voluntarily, as I've said, by the parties, which when successful has, among other things, the effect of making it much easier for parties to abide by the agreement reached in the mediation, because the parties decide how they wish to settle the dispute, if at all. Ironically, mediation is a formal process of an informal yet intricate nature of the many features which distinguish mediation from its cousins within the alternative dispute resolution family. The relative informality with which it's conducted is one of them. In truth, however, it is in fact a formal procedure with its own guidelines and rules. However, it is deliberately veiled with informality as a means to, amongst other things, intentionally remove the rigidity that which increasingly degree of intensity characterized its cousins in the litigation and arbitration fields. In my view, the most valuable aspect of mediation as a tool to resolve disputes of any kind is how it empowers the parties to the dispute by placing the resolution of their disagreement squarely in their hands. Therefore, it is important as well for us as mediators and as we conduct our alternative dispute resolutions to empower the parties. But yet, when you look at alternative dispute resolution, it requires quite an intricate skill from us. And I'm confident that our speakers today, as I've seen, are very well experienced, and that they will assist us in acquiring that skill and also in polishing the existing skill, but also in learning the universal tactics in dealing with matters of mediation. As we all know that social justice, also governed within the community of the law, is not static. We learn from different jurisdictions and jurisprudence from time to time, and it is critical for us then to also quench our thirst from time to time from one another. I wish you all of the best for the rest of the proceedings. I thank you.
Thank you very much, Advocate Galeka, for that. I would also like to thank the welcome remarks by Mr. Adrian Balengera. I would like to apologize. My camera it was working before. I'm not sure what has happened and I'm failing to fix it, but we'll just proceed as we are. Thank you so much. I think the welcome remarks have been said well, and the reason why we are all here today. As mentioned earlier on, I said I'm facilitating the webinar on behalf of Commissioner Dr. Elasto Hilarius Mugwadi, who is the chairperson of the Zimbabwe Human Rights Commission. I head the Complaints Handling and Investigations Department within the Commission. And it has been alluded to that today we have 3 speakers. I will then briefly introduce each speaker before they make their presentations. We will have a question and answer session after all the presenters have made their presentations. And if anyone has questions, please feel free to put them in the chat box. With that being said, I will introduce the first speaker, who is Mr. Chijoke Nana Ibeku, who will present on the values and guidelines of interest-based negotiation in resolving dispute. Mr. Ibeku is a distinguished lawyer, certified mediator, counselor, author in mediation and property management. He is a firm believer in God. He is the founder and principal partner of the 3 C's Meet International Institute of Mediation, Negotiation, counseling, and conciliation. He is a member of the Nigerian Bar Association. He is an alumnus of St. Gregory's College in Abia State. He is happily married with 4 children. Mr. Ibeko, I hand over to you to make your presentation.
Yeah, good morning, everybody. Thank you for having me. It's indeed an honor and pleasure to share one's humble knowledge in the field that has been brought to the fore this morning. You pronounced my name well. The other people didn't actually do that. My name is Chijioke Nnanna Ibeko. But that be that as it may, I think you made a very good attempt. I listened to the lady before you talk about mediation, and I think she did justice to it. As we all very well know, mediation is amongst the tools in the ADR family, the ADR mechanism, alternative to dispute resolution mechanism. And I would like to, we have a mantra at my firms. We say there is no better time for the practice of mediation than now. Why do I say that? The world is faced with a lot of uncertainties. The disposable funds and the amount of money one has for a lot of issues are limited. Like I said earlier, faced with a lot of uncertainty. So what is the best tool for conflict resolution? If you really check, to me, and I dare say it must indeed be mediation. We all know very well what mediation means. A formal process, a third party neutral comes in to settle a conflict between 2 or more parties, or between 2 parties, I beg your pardon. A third party neutral. All he does is like a facilitator, like a sponge when you're batting. That washes your parts, but you're the one that knows where you're taking it to. So the party is a party's process. You're the one that knows where you want the sponge to touch your body. But the sponge does the work. And that is what basically the mediator is all about. Guided by what the parties want to do, but only by the mediator's experience, because he must have handled such matters before the present one before him. So mediation is actually very key. And like I said earlier, no better time for the practice of mediation with regards to the world we are facing presently. Now, back to my topic. The topic I was specifically told to talk about was the interest-based negotiation in dispute resolution. And I'd like to begin with the definition of negotiation. A lot of people may know what negotiation is, or may not, or may mix it up. So I thought it wise to say, okay, what is negotiation? Negotiation is a dialogue between 2 or more people to reach a desired outcome regarding 1 or more issues in conflict. I'd like to take it again, a dialogue. In other words, you're talking, you're relating to one another, trying to reach a desired outcome regarding 1 or more issues in conflict. And when you're beginning to talk, when you're beginning to exchange ideas, trying to reach a desired outcome, there must be obstacles. You must face some issues that may not be contemplated. You may think on the spot, and somehow, by benefit of your negotiation skills, you have to get to a point where you people reach a desired outcome. A lot of people mistake negotiation for bargaining. A lot of people mistake negotiation for, and bargaining is not negotiation. Bargaining is just what the other party wants. What the other party wants. It's just a process in negotiation. Negotiation is a dialogue between 2 or more people to reach a desired outcome regarding 1 or more issues in conflict. And also, for instance, too, a lot of people also mistake negotiation for mediation. Mediation is just, is just between 2 parties. I beg your pardon, negotiation is just between 2 parties. Then mediation is between 3. The person is a neutral, comes in to see how he can reach an agreement, how he can guide the parties to reach a desired agreement. So a lot of people mistake these terms, but the very funny thing about it is for you to be a good mediator, you actually need to have good negotiation skills. For you to be a good mediator, if you do not have the basics of negotiation, you may not really get to the point you want for the parties to reach a settlement agreement in mediation. So these things are intertwined, but we have to be very careful not to jam-pack it and cause confusion for people that may want to benefit from what we're about to do today. So having said that, I think to a certain extent, I've put all this in perspective. That yes, mediation is really very different from negotiation, but they're intertwined. For you to be a successful mediator, you really need to have the good basic knowledge of mediation. you really have to have a good basic knowledge of negotiation, for you to be a good mediator, because negotiation is for you to get the parties to reach an agreement. You can imagine when you're doing something that is voluntary. It's not, you're just doing something because we all know that mediation is a voluntary process. One person can say, I'm no longer interested. So for you to get them to that desired outcome, for you to get them to the desired outcome of a settlement agreement, you really need to possess a good skill in negotiation. Now, we now go down to digress further to what is interest-based negotiation? It's simply a process-solving approach to conflict that is centered on our needs, on our desires, concerns, other than our position. I was privileged to be in a class. I'm acquainted with her. Her name is Denise Kitts. She's a very high top negotiator. And you know, in life, we need to have, for us to have, a lot of people could say, why do you still have conflicts when you have mediation, when you have all those? A lot of things are when people misconstrue or feel they know, then you have a lot of issues that may span out from those discussions therefrom. So I had, like I was saying, I had the benefit of experience by being acquainted with Denise Kitts, a top negotiator in the world. And you know, these things have to be reduced for you to get, when you're negotiating, you need to reduce it to simple terms, even to the childlike. You need to see yourself like a baby, a child, so that you appreciate things as they ought to be, and in fact, as they are. Because if you have a set mind and you go into a negotiation process, there's going to be a bottleneck. It's going to be jam-locked. You're not going to get any solution, that desired outcome. So having said that, you need to take these things easy. You need to take it simply, simplify it so you can understand it better. I like to take again, interest-based negotiation is simply a problem-solving approach to conflict that is centered on the needs, desires, and concerns other than position. What is the position? Position is, why do you want what you want? The interest is what we want. I want this. The position is, why do you want that? So once you can demarcate between what you want and why you want it, then you're almost near to solving your problem. You're almost near to solving the problem. And you know, in interest-based negotiation, you're either going to have, when you're negotiating, you're either going to have a win-win, a win or lose, or a compromise. For instance, if you could say, okay, I'm going to take 100, somebody demands I must take 100 bottles of Coke from this company today. You could have an instance where you could say, okay, we can't afford to give you 100. We can afford to give you 50. That's a compromise. Or we're not going to give you at all. That means you've lost out. Or have this, have the whole 100, you've won. So these things need to be taken in perspectives, as it might sound as simple as it is. And I beg your pardon if it sounds so simple, but I have to make it this simple because I think when it's simplified, we begin to understand these concepts. We begin to put them into practice. And as we put them into practice, you see that a lot of things you might have thought were very difficult in real life situations are actually very easy. I'd like to give an instance. Like I said, I beg your pardon, but that is how I have managed to get across some of these things I do when I'm called in such fora like this. I have a program that I'm nurturing, and I dare say I'm the pioneer of that program in Africa. It's called peer mediation. It's teaching children about the practice of mediation. And we have brought this concept of negotiation into the practice. It's one of our contents for the children to appreciate. These children, their ages range from 7 to 15 and 15 to 19. But we are presently working at 7 to 15. Now you see two children who had an issue in a practical class. Two children, we had a biro, a pen for them to write. And there were two children sitting beside each other in a class that we are trying to assess. We intentionally did that. And I threw the biro. I intentionally threw the biro to them. And one that was faster caught the biro. I remember I said that we were getting ready for an assessment. And the one that caught the biro was very particular of the biro she wanted. She wanted a blue biro. And incidentally, the biro that was thrown to her was a blue one. The other one did not get. And what is the actual need for the biro? It's for you to write for the assessment. We are just trying to put these children to understand what negotiation is all about. Yes, but the biro, the pen is meant for writing. There's no other thing for the pen than for you to write. And yes, what was interest for that day? It was for us to write an assessment. So in other words, it doesn't necessarily have to be a blue biro that you must write with. You could also do that with a black biro. And once you've got the children to appreciate that you must always be interested in your position. You must always be interested what you must be very interested is why you want what you want. So that you don't hold fast to a lot of things. And when you see that there's a superior need to yours, you now give in to that need for the better good of all. And I think we got to that extent, and we managed to get the children to appreciate negotiation as regards, as simple as it is, the pen for writing. And I'd like us to take another look at the 4 types of interest. And this is actually, everything we do in an interest-based negotiation all stem around the main things I'm going to mention. Now, one is economic, the other is security, recognition, control, issues, and desires. I don't know how many minutes am I going to dwell more on this, or do I just mention them? Like I understand I was going to do a paper and send forth to you people. I don't know how many minutes. Am I still within time?
Yes, you have a 15-minute presentation.
So I'm still within time, I guess.
Yes, you are.
Okay, so basically the economic issues we all have. We all know what the economic issues a lot of countries are faced with. If you do not appreciate the interest-based negotiation as regards the economic issues, a lot of countries still are at the low because they've not taken into consideration what they want and why they want it. You need to have a clear demarcation between these 2 lines. And once you have it, why you want something, what you want, if you give it up, what are the consequences? How much will it hurt you? Can I actually do without this? Once we're able to access all this within a template, you will now know that basically you're having things easier to yourself than it should ordinarily be. We'll talk about the security. We can see what is happening in Ukraine. The Russians and Ukraine. It's all about interest. It's all about interest. The Russians want the Ukrainians not to get involved in NATO. We all know what, I don't want to dwell much on that, but we all know what the consequence, what the whole background of that is all about. But it's all based on what we're talking about today. There has to be a giving, there has to be something that you have to do that we must basically, remember when I made the introduction, or when I defined what negotiation was all about, it's a desired outcome. We must have a desired outcome that is compatible not only with one of the parties, that has to be compatible with all the parties. Even if it's not going to be completely compatible with them, there has to be a compromise where to a certain extent you're satisfied and the other party is satisfied. There must be a win-win or win or lose. And if you have a win or lose situation in negotiation, that's where you almost have a bottleneck because nobody comes to negotiate for something and loses out completely. You must make somebody feel that yes, as you participated in what you're doing, there is a level of outcome you may have had. You may not have had it 100%. And that is why those of us who are pushing strongly for the practice of mediation are doing that. Because in the mediation process, considering all the advantages that mediation pretends or presents, apart from the cost effectiveness, the preservation of relationships and speedy resolution of issues, that's why we're pushing vigorously for the entrenchment of the practice of mediation. And if you bring it in basically in mediation as a practice, we will all appreciate that because of the times where I had made a position in a fora, in different fora I've had the opportunity or privilege to talk about, that sooner than later, mediation will no longer be an alternative. The way things are going, mark my word, mediation will no longer be an alternative to the dispute resolution, but it will actually be a main thrust because people are getting fed up of having issues that they can easily resolve. A lot of people are passing through a lot of dire times. So if you have the process that can make things easier for them, why would they want to be in a burdensome process? They'll rather look for a way out to meet up that desired outcome they will prefer. Many people, and I apologize to arbitrators who may be here. We all had a time when arbitration was like the way out. But now we are seeing that mediation is gradually overtaken, particularly with the Singapore Convention. We are seeing that mediation is gradually overtaken because people are now beginning to relate arbitration to a junior brother to litigation. You're trying to sway from litigation, and you're seeing another technical part in arbitration. So a lot of people are saying, why don't we explore mediation? It seems to be the most practicable approach to conflict resolution. Be that as it may, then I'd like to talk about the 4 conflict negotiation strategies. We have to consider the interests and values separately. So when we say this, what does it mean? It means you just separate the person from the problem. You have a negotiation on board. Do not clamp the individual and the problem together. Begin to look, if you have an individual, just separate the person from the problem. Address the problem and try and see how you can reach this desired outcome in the process of negotiation. Engage in relationship building dialogue. You know, the interesting thing about negotiation is that if you had a prior issue with somebody before time, if you could soften a little bit, a bit of compromise to what that person never envisaged you're ever going to give into, plus or minus, you might to a great extent have a greater output in your desired outcome than you even imagined. A lot of people, a lot of issues that go around are people misconstruing what they thought the other person had in mind. As a law student in those days, I remember a particular lecturer telling us in one of the classes that I think it was a criminal law class, that even the devil does not know the intention of man. And I have never forgotten that. Even the devil does not know the intention of man. So you cannot presume you know what the next person is thinking. So when the person says, okay, I'm giving in a little bit to what you never envisaged he or she was never going to give into, the tendency, the natural tendency is that you may be forced or cajoled to give in also to meet up that person's level of compromise in that particular issue. And all this stems from engaging in relationship building dialogue. Then you appeal to common shared values. Even if you have a problem about negotiation on the table, there is a place, no matter how the dispute is heated up, there is always a sure point of agreement. There's always a sure point where both of you share a common interest. The only problem in negotiation is that most people do not look at that place where they share common interest. You begin to look for the differences. And I think in the skill of negotiation, I think the most important thing is to begin to look at that place where there's a common interest. When there's a common interest and you're coming down the ladder to a place that there are differences, the chances that you may get to both parties to agree completely is higher than when you start with the point of differences. Because the point of differences actually builds more tension. But if you have the place where they have common shared values, and there's nobody in this planet of called Earth where you do not have, no matter how heavy or intense the disputes are, there is a point of common shared values. There is a point the two parties involved in the negotiation, yes, know that this is, thus far can we go, and this is what we can accept, this is what both of us believe in. Capitalize on that, and once you capitalize on that and get them on the same page, then plus or minus, as you begin to go down the ladder to the point of differences, there are greater chances that indeed you will get the parties to get to a desired outcome. Thank you very much.
Thank you very much for that insightful presentation, Mr. Ibeku. May I just remind everyone that interpretation is available at the bottom of their screens. For Arabic language, it will be in, please choose German. Just to highlight quickly what Mr. Ibeku had presented, he highlighted that negotiation is a dialogue between two people trying to reach a desired outcome. And this is regarding one or more two issues. He also explained what negotiation was not, highlighting that the difference between that and mediation. He further defined interest-based negotiation as problem-solving approach and proceeded to give us examples. He also just explained strategies which include relationship building processes as well as common shared values. I will then move on to the next speaker who will speak, and that is Honorable Professor Gabriel Sandro Savino, who will be presenting on the guidelines of mediation as a means of resolving disputes, as well as the work and the tasks of the Ombudsman of Santa Fe Mediation Unit. Honorable Savino is a father to 4 children. He is currently the Ombudsman of the province of Santa Fe, Argentina. He was appointed in 2019 to 2024. He is also in charge of the Ombudsman for Children and Adolescents for the province of Santa Fe. He is a distinguished political scientist, university professor, community mediator. He is also a specialist in public management, a seasoned negotiator during crisis. Honorable Savino, I hand over to you to make your presentation.
Bueno, hola a todos y todas. En realidad agradecerles la invitación. Espero estar a la altura de los exponentes que tenemos hoy. En primer lugar, voy a tratar de hablar despacio para que pueda ser interpretado. Como dijeron, bueno, mi rol es de defensor del pueblo en la provincia de Santa Fe, una provincia rica y que tiene 4 millones de habitantes desde Argentina. Es una provincia rica culturalmente y productivamente. Nosotros en la Defensoría del Pueblo tenemos un promedio anual de 5.000 expedientes tramitados. Yo voy a hablar primero como defensor del pueblo y defensor de niñas y adolescentes. Segundo, como docente universitario y justamente docente también en negociación y mediación. Y tercero, por mi experiencia, yo hace 20 años que estoy dentro de la Defensoría del Pueblo, soy director de carrera y hoy tengo el placer de ser defensor del pueblo y la responsabilidad de ser defensor del pueblo. Y como mediador también, y la experiencia como mediador, nosotros en la Defensoría del Pueblo, que funcionalmente es una institución autónoma dentro del poder legislativo, que no recibe mandato de ningún poder del Estado, que posee como característica una Defensoría del Pueblo, una de las primeras Defensorías del Pueblo de Argentina y de Sudamérica. Y nosotros, para que se entiendan cuál es la metodología de nuestro trabajo y por qué llegamos y tenemos un centro de mediación, nosotros tenemos una atención ciudadana donde se trabaja todo el tema de servicios públicos, salud, educación, seguridad, prestaciones, defensa del consumidor, infraestructura, ambiente, inclusión. Digo, eso es la atención primaria. Desde hace casi del año 93 nosotros tenemos un centro de asistencia a la víctima y testigo del delito, que fue también el primero en la provincia y referente de abordaje de distintas tipologías de violencia, y eso también lleva a la intervención en distintos procesos de resolución de conflictos, como los temas familiares, de género, el maltrato infantil, el maltrato institucional, el maltrato con los adultos mayores, el tema de la violencia laboral, la movilidad humana, la trata de personas, digo, la explotación sexual. Muchos de estos temas también en algunos aspectos terminan en procesos de resolución de conflictos. Desde el año 1994 nosotros contamos con un centro de mediación y resolución de conflictos donde se realizan no solamente mediaciones y también se realizan facilitaciones, como acá se habló de la mediación como proceso formal y la facilitación como un proceso intermedio con más de 1.500. Nosotros formamos también mediadores, tenemos un instituto de formación de mediadores En estos 30 años hemos formado casi 1.500, hemos entregado 1.500 certificaciones. Asimismo, estos últimos años, como organismo protector de derechos, hemos ampliado, la ley nos amplió funciones, como tenemos legitimación procesal activa del defensor del pueblo, se incorporó el órgano de revisión de salud mental dentro de la defensoría. Asimismo, nuestra defensoría, del cual yo era director, de descentralización territorial, hoy contamos con 2 sedes centrales y con 46 oficinas en nuestro territorio y 3 oficinas móviles que recorren el interior, lo cual hace la intervención institucional mucho más amplia y justamente ver estas conflictividades mucho más comunes, ¿no? Más allá que nuestra provincia tiene 1.000 kilómetros de largo, las realidades son totalmente distintas. En el año 2022 formalizamos dentro de la estructura, después de 30 años, el Instituto de Formación y Modernización de Gestión Pública de la Defensoría del Pueblo, lo que hace es formar con perspectiva de derechos humanos. Dicho esto, voy a hablar con lo que tenía preparado, y lo primero que quiero dejar es empezar, más allá de empezar a hablar de mediación, que es el tema que me toca, hablar de conflictividad, ¿no? ¿Por qué digo esto? Y como el expositor anterior habló también y introdujo la negociación y el tema de los conflictos, tengo que decir que toda conflictividad se origina cuando hay una pretensión, alguien que pretende algo, y otra parte que se le opone una resistencia, no está de acuerdo con lo pretendido. Y ahí empieza el origen de todo conflicto, ¿no? Y cuanto más pretensión y resistencia surja, comienza a haber distinta intensidad del conflicto, ¿no? Y esta intensidad lo que marca la conflictividad y la intervención que uno le tiene que dar, porque no todos los conflictos son semejantes o son iguales. Por cuanto debemos tener en cuenta esa dimensión donde se produce, según sea el entorno familiar, el entorno laboral, el entorno comunitario, el entorno social, si es el entorno privado o público, si tiene incidencia en cuestiones religiosas, cuestión urbana o rural, digo, entre instituciones, entre funcionarios, entre ciudadanos y funcionarios, entre pueblos originarios, si son cuestiones étnicas o, como dije, religiosas, donde muchas veces hay desequilibrio de poder entre las partes, no hay igualdades. Y justamente estos conflictos se ven y se deben abordar de distintas formas. Una de las cuestiones que nosotros tenemos que tener presente, porque vamos a encontrar cuando intervenimos en conflicto que hay historias pasadas que se vuelven vigentes en ese punto de conflictividad. Para entender esto que digo como dimensión, visualizamos el conflicto muchas veces como una espiral con mesetas y escaladas, como el ciclo de vida que tiene un origen, un nacimiento, un crecimiento, un desarrollo, una muerte cuando se resuelve el conflicto, o bien uno piensa que se resolvió y sin embargo queda en latencia, ¿no? ¿Por qué? Porque el conflicto siempre está en escala si uno no interviene en tiempo y forma. Muchas veces creemos que resolvemos el conflicto porque no se habla de él, sin embargo, este conflicto queda en latencia, ¿no? Y cuando resurge ese conflicto, surge con mayor y mucha mayor intensidad. Y muchas veces esa intensidad determina cuestiones que muchas veces son incontrolables. También debemos mencionar que en estos conflictos no solo puede darse entre las partes, como se dijo anteriormente, sino en nuestra experiencia como intervención en multipartes, un montón o un grupo de actores. Esto surge en nuestras intervenciones en conflictos barriales, en tomas de instituciones, en toma de espacios públicos, en movilizaciones, en corte de vías públicas, digo, donde la intervención tiene otra lógica, ya no es una mediación, como hablaron recientemente, como proceso formal, sino muchas veces en estas intervenciones multipartes o generales hay distintos puntos y distintos enfoques. Hablaron recién de la negociación. Siempre la negociación como temática está presente. En cualquier método de resolución del conflicto, la negociación es la base. Y también nosotros como organismo de derechos tenemos que empezar a visualizar problemas nuevos. Siempre uno habla que en la intervención siempre hay un otro. Bueno, lamentablemente hoy, con los avances tecnológicos, muchas veces en las nuevas problemáticas no hay un otro, que son las problemáticas que se dan en el entorno digital. Y esto genera muchos agravantes, como hablar de grooming, de phishing, de ciberbullying, de estafas virtuales, de sextortion, stalking, sexting, digo, entre un montón de cuestiones que hoy tenemos con la tecnología y la virtualidad, y cuál es la intervención que nosotros tenemos que realizar cuando hablamos de resolución de conflictos. Y cuando hablamos de demandas, conflictos y resolución, sabemos que los tiempos de la política no son los tiempos muchas veces de la gestión pública, los tiempos de la gestión o la administración pública no son los tiempos de la justicia, y los tiempos de la justicia nunca son los tiempos de la ciudadanía. Y por eso muchas veces estamos nosotros como instituciones protectoras de derechos las que debemos representar y estar atentos a todas estas nuevas demandas, al menos para lograr que todas las conflictividades no escalen o se tornen fuera de control, tornándose estas situaciones en cuestiones críticas donde los abordajes deben ser totalmente diferentes. Por eso, muchas veces, cuando hablamos de estas metodologías que tienen que ser una alternativa a la vía judicial, el debate hoy que nosotros tenemos, no solamente en mi provincia, sino en Argentina, con el tema del delito o la inseguridad, es muchas veces un debate binario. O se endurecen las penas con mayor sanción, o se ablandan las mismas con mayor garantismo. Y ese es un debate en nuestro sistema que ha fracasado, ¿no? Porque la resolución, justamente la intervención de procesos conflictivos, siempre lo tuvimos como un pensamiento binario, blanco o negro. Y hoy los conflictos tenemos que pensar y abordar lo que son multidimensionales. Y se debe pensar con abordaje o desde el abordaje complejo e interdisciplinario, no lineal. Debe ser también un abordaje multiagencial, abordados de diferentes instituciones, muchas veces de acuerdo a las complejidades del conflicto. Y esto nos lleva a esforzarnos como funcionarios, como defensores del derecho humano, y también comenzar a deconstruirnos nosotros mismos para comenzar a entender el otro en sus complejidades, y esta es una construcción conjunta, no desde el plano discursivo, sino del compromiso real de los gobiernos, de las instituciones, de los funcionarios, de los ciudadanos. Digo, esto deberíamos empezar a entender las soluciones con el esquema de gobernanza, ¿no? Por eso, nosotros, desde nuestra institución, desde mi experiencia personal, siempre defendemos el abordaje de conflictos por los medios alternativos y pacíficos, para que no escalen en una dimensión mucho más amplia, mucho más conflictiva. Siempre privilegiamos no llegar a la vía judicial, buscando alternativas metodológicas de intervención, más allá que pueda haber un sistema de mediación. Nosotros tenemos sistema de mediación comunitario, como la Defensoría del Pueblo, que es gratuito, voluntario, pero también tenemos un sistema de mediación prejudicial instaurados, y al menos nuestra experiencia es un sistema que ha fracasado. Hoy, mientras la mediación comunitaria, el 85% tiene resolución efectiva y positiva, en la mediación, los últimos datos de este último informe 2022, la mediación prejudicial, la resolución positiva es solo del 22%. Es por ello que como metodología para abordar e intentar resolver conflictos por fuera de la vía judicial, nos manejamos en primer lugar lo que tiene que ver con la negociación, que bien fue planteado por el expositor anterior. Nosotros con la mediación comunitaria, como dijeron anteriormente, como proceso formal, un tercero imparcial, que las partes voluntariamente desean resolver una controversia. Siempre tiene que haber voluntad de las partes, porque si no, si una de las partes no tiene voluntad, seguramente nunca podemos hacer una mediación o procurar hacer una mediación exitosa. Tengo que decir por mi experiencia, el mediador no propone soluciones, que es un error frecuente que hacen los mediadores, tratar de intervenir y dar su opinión en la solución. No lo debe hacer, debe guardar el sentido común, que las partes negocien entre sí y más allá, esto nos da, cuando las partes negocian y llegan a un arreglo, un acuerdo, el acuerdo va a ser de larga duración. Cuando intervenimos como mediador, seguramente ese acuerdo que no fue originado por las partes sinceramente, llega un momento que no se cumple. Por eso, la mediación como proceso formal, voluntario, gratuito y confidencial, nuestra experiencia es de gran éxito. También aplicamos la facilitación, que es un proceso o el amigable componedor. En pandemia y pospandemia se acrecentaron la utilización de esta metodología a través del uso de plataformas digitales. ¿Por qué hablamos de facilitación y no de mediación? Porque se dio un paso de lo físico a lo digital, que se acrecentó con la pandemia, donde los temas cambió la kinésica, ese lenguaje personal, cambió la proxémica, los espacios privados e individuales, cambió el paralenguaje, los elementos no verbales. Las plataformas hizo un cambio de forma de abordar el conflicto entre partes. Y este proceso de facilitación, que nosotros lo trabajamos y lo trabajamos mucho desde la Defensoría, como sí también con la mediación comunitaria, cambió el proceso llevándolo un poco más a la informalidad, ¿no? Y aquí sí, este facilitador, que muchas veces era el mediador, es ese amigable componedor. En muchos casos conoce las partes. Yo antes dije que teníamos muchas oficinas, 46 oficinas en el interior, que muchas veces en localidades chicas el funcionario que trabaja conoce a las partes, entonces no se puede realizar una mediación formal y se utiliza esta metodología como una intermediación, alguien que vincula y comunica a dos o más partes para alcanzar una propuesta satisfactoria para ellos. También se va a hablar aquí del arbitraje como otro método de resolución de conflicto, ese tercero con reglas aceptadas por las partes involucradas, tratar de tomar una decisión sobre una problemática, la conciliación como otro método, ese tercero que interviene y colabora para que con tenor jurídico las partes resuelvan por sí mismas y mediante un acuerdo. Digo, hay muchos métodos para resolver conflictos y la mediación es uno de ellos importante, pero también hay nuevas intervenciones que venimos realizando en nuestra institución, tanto en la Defensoría del Pueblo como en la Defensoría de Niños, Niñas y Adolescentes, y más cuando abordamos, como habló mi antecesor, cuando hablamos nosotros en la Defensoría hacemos mucha mediación escolar, armamos equipos y formamos mediadores escolares que eran los mismos chicos, una experiencia muy buena. Hoy, con la Defensoría de Niños, Niñas y Adolescentes estamos trabajando en intervenciones restaurativas o justicia restaurativa. Se pretende una restauración o modificación de una conducta para ponerlas en el estado o la estimación que antes tenía esas personas o ese conflicto. Es una metodología que comenzamos a trabajarla hace unos años, formando personal, formando agentes, y nos está dando muy buenos resultados. Por eso digo, lo quería traer aquí a este seminario, porque como metodología o métodos para resolver conflictos hay muchísimos, y uno aplica el que mejor obtengamos resultados. Esta nueva metodología de intervención que estamos utilizando como herramienta o nueva herramienta se da porque cambiaron las relaciones humanas y hoy debemos entender totalmente distintas las relaciones humanas. Es una nueva perspectiva de abordaje de conflictos entre las personas y el rol de derechos. Este perdón recompositivo, sanción recompositiva, debemos tener presente como otra alternativa más. Y aquí voy a hacer algunas consideraciones. Restaurar no es lo mismo que reparar, por cuanto restaurar no es lo mismo que mediar. Digo, son distintos métodos. Reparar equivale y se asimila a la idea de sanción o indemnización por el daño causado. Es recompensar el espacio afectado. En cambio, o a modo diferente, la intervención restaurativa es equivalente a observamos el daño, no de su versión tangible, sino en su versión intangible, más en el trabajo diario cuando se vulneran derechos. Es decir, recompongo el reconocimiento o la responsabilidad del espacio dañado de derechos humanos. Recompongo el vínculo entre la víctima y el victimario, el agresor y el agredido, más allá del daño ya producido y muchas veces que no se puede restablecer. Por eso, esta nueva forma o metodología de abordaje necesita de la comprensión de todos. Es muy difícil abordarlo desde un pensamiento binario. Por eso digo, muchas veces tenemos que deconstruirnos nosotros mismos con nuestra historia, nuestro pensamiento, nuestro conocimiento, para empezar a entender las necesidades del otro. Romper las percepciones del conflicto. Focalizarnos no solamente en intereses, sino también en las necesidades. Y muchas veces las necesidades no son materiales. Muchas veces las necesidades son intangibles. La idea del perdón, pedir disculpas, darse cuenta del daño causado. Eso es un salto hacia adelante que tenemos que tener en cuenta. Y este intervencionismo restaurativos como nueva forma de ver el conflicto, un escalón un poco más alto de lo que es la mediación comunitaria, es la práctica que estamos llevando, sin dejar de lado la mediación, sin dejar de lado la facilitación. Estamos interviniendo en esta nueva metodología, más cuando hay menores en conflicto con la ley penal, más cuando hay menores involucrados. Es lograr un cambio de enfoque, cambio de paradigma, ya no causa-efecto, ¿no? El encuentro muchas veces es diferente entre el que perjudica y el perjudicado.
May I ask you to round up the presentation?
Hola. Hola.
I was just asking if you can round up your presentation. Thank you.
Ok, gracias. Por eso, las nuevas, como dije, las nuevas metodologías de intervención, creo yo que en este seminario hay que poner no solamente los métodos conocidos, sino nuevas metodologías de abordaje de conflictos. Así que mucho más para decir no tengo, así que agradezco el espacio y estoy abierto para las preguntas. Muchísimas gracias.
Thank you very much, Honorable Safina, for that presentation. It was very insightful. I think he spoke about how they set up the mediation and that they also offer training. He also highlighted the complexities of conflict resolution, and the complexities of which include technological challenges. He also highlighted that they have a new method that they're using, which is restoration rather than reparation, and that they've been using as an office, and they have found success in this approach in more complex cases, especially that involve children. I think his presentation is summed up in the fact that conflict is not always addressed in the same way. Each conflict has peculiarities. Each person involved has different perceptions, interests, and needs that influence their context. So we need to take that into account. Before we then move on to the next to the question and answer session, we will now move on to the third and final speaker, who is Mr. Chidi Martins Lasbury, who is presenting on the values and guidelines for conciliation as a means of resolving dispute. Mr. Martins is currently the Vice President in charge of marketing and membership drive for the Institute of Chartered Mediators and Conciliators, known as ICMC. He is also the former National Director of Training of the ICMC, immediate and past National Director of Marketing and Membership Drive of the ICMC. He is also a fellow of the same. He is an accredited conflict manager with Mediation Training Institute International, USA. He is a member of the Lagos Court of Arbitration and a member of the Lagos Court of Arbitration Panel of Neutrals, and many other qualifications that he has. Mr. Martins, I hand over to you to make your presentation.
Thank you very much. Good morning, everybody in the house, the AOMA and AORC team. I am happy to be here, and thank you for the privilege. Now, having listened to all the speakers that have spoken before me, I think my job is a lot easier. I've been asked to talk about conciliation and these values and guidelines and related things. But I just want to say something. Having listened to the first two speakers, I've just noticed that one thing is clear, and it's something I know before now, and that is conciliation is a structured process, a fairly structured process. It is indeed structured. And I also want to add here briefly that mediation and negotiation, they are localized. All of them speak the local language. I will come to that later. Having said that, I don't know if you can see my slides now. Can you see my slides?
Yes, we can see your slides, sir.
All right, great. And just like the speakers earlier have said, that judiciary globally has been overburdened with case dockets. People are struggling every day with cases that ordinarily they should sit around the table to discuss and iron out solutions. People are hanging in court for issues that ordinarily have no business being in court. And in today's world, the judicial system, is so frustrating. People need a quick and affordable and effective system of resolution of disputes. It's a true saying that the right to speedy trial is a right to life and personal liberty. Timely disposal of cases should indeed be a fundamental right of citizens. As justice delayed is justice denied. That's a true saying. So people are seeking for solutions, urgent solutions. In fact, 24 hours is no more. In fact, it's no more enough. People are busy. Businesses are transacted at breakneck speed, and we just cannot continue to wait for the judiciary and their protocols and bureaucracy. So alternative sources have to be developed or designed. We've talked about negotiation, we've talked about mediation. Now it's conciliation. And we are saying that conciliation basically is a non-binding process in which an impartial party is appointed who assists the disputing parties in reaching a mutually beneficial agreement for the settlement of their dispute. The key here is party agreement. The key here is impartial third party. The conciliator assists the parties in an independent and impartial manner in their attempt to reach an amicable solution to their disputes. Similar to mediation in many ways, however, there are a few differences between mediation and conciliation. Hence, we say that the difference between mediation and conciliation is like the difference between 6 and half a dozen. In fact, in some climes, the two words, mediation and conciliation, are used interchangeably. Though formal in some ways, conciliation process is more formal than mediation in some ways as well. If you look at this beautiful picture of mine, the first segment of this picture it's a picture of what happens when people are in dispute, not knowing what to do. Everybody is selfish about it. Everybody wants to have his way, but it doesn't work. At some point, they will see their mistakes and they decide to talk to each other, say, hey, come. Instead of us hanging ourselves allowing this rope to hang us, let us have a conversation and work out an amicable solution. And if you go to the third session, you see two of them now jointly going to finish one portion of the food, and lastly the other portion of the food being jointly eaten. So basically, in a nutshell, that is what transpires in a dispute resolution session, whether it is mediation, conciliation, or negotiation. Now, we come to the conciliator. Who is the conciliator? The conciliator is supposed to be impartial and conduct the conciliation in an impartial manner. He is guided by the principle of objectivity, fairness, and justice, and by the usage of the trade concerned and the circumstances surrounding the dispute, including any previous business practice between the parties. The conciliator is not bound by the rules of procedure and evidence. The conciliator does not give any award or order. He tries to bring an acceptable agreement as to the dispute between the parties by mutual consent. So he doesn't impose any decision on them. The agreement so arrived is signed by the parties and authenticated by the conciliator. In some legal systems, the agreement so arrived at between the parties resolving their dispute has been given the status of an arbitral or consent award. So it depends on the claim where you're operating. Having said that, I said earlier that there are some striking differences between mediation and conciliation. For example, the conciliator must be appointed, while the mediator can intervene in a matter. Two friends having an issue, a mutual friend of theirs can say, hey, stop quarreling. Can I assist you in, come in to say how can I assist you to help you resolve your matter? A mediator can intervene, but a conciliator must be appointed. And the reason is simple, because the conciliation process is backed by statutes. A whole lot of countries have developed their own conciliation and arbitration acts. In my country, Nigeria, we have the Arbitration and Conciliation Act, Cap 18, Laws of the Federation of Nigeria, 2004. And that is the guiding principle for arbitration and conciliation. So everything we do regarding conciliation have to follow through those patterns, except maybe where the parties decide to vary it here or there. The conciliator enjoys the wider latitude and privileges in his operation than the mediator. Yes, it's a more formal process. He has a lot of powers. And in fact, if you look at the mediation model, for those of us who have gone deeper into mediation, we'll see that there are different models of mediation. You see that conciliation aligns more with the evaluative mediation model that has to do with subject matter expertise, that has to do with kind of getting involved in the process. The conciliator can carry out his or her assignment to a reasonable extent based only on documentary evidence, while the mediator cannot lift a finger except the two parties are seated before him or her. And the conciliator can also suggest settlement terms to the parties. He can do that. Yes, he has the authority to do that. So these are some of the, briefly, some of the differences between mediation and conciliation. There are more, or there may be more, depending on where we are coming from. Now, what I would do is go through the application of mediation, because it's a statutory, I mean, it's statute bad. I mean, because it has statutory backing. So I have to go, what I will do now is to go through the application, the various articles that make up the Conciliation Act. But doing this, I want to align myself with the UNCITRAL conciliation rule. UNCITRAL is the United Nations Commission for International Trade Laws. UNCITRAL, United Nations Commission for International Trade Laws. If it's a public document, you can Google it and see what they have there. So what I would do here now is to glean from that UNCITRAL rules, of course, in an abridged version because of time, so that we can quickly go through the conciliation process, what is expected. Article 1 talks about application of the rules. These rules are governed by party agreement. Whatever we do in conciliation, whether mediation or whatever, is governed by party agreement. In fact, we say that all these ADR processes, or most of the ADR processes are just a basket or baskets of agreements. Because everything you do, everything and anything you do must be a product of agreement for you to progress. The parties may agree to exclude or vary any of these rules at any time. Where any of these rules is in conflict with the provision of this act and any law from which the parties cannot derogate, the provision of the law prevails. So anytime there's a conflict, the law prevails. That's talking about Article 1, which is application of the rules. It's like saying, if in the course of this transaction, any dispute arise, we have agreed to deploy mediation as conciliation as the preferred option. Article 2 talks about commencement. Now that the parties have agreed on the process to deploy, how do they commence? Naturally, the aggrieved party activates the dispute resolution clause in the agreement. Just the way you file a suit, the aggrieved party files a suit. In mediation too, the aggrieved party initiates the process. Article 3 talks about the number of conciliators. The parties have to agree on the number of conciliators. There shall be one conciliator unless the parties agree that there shall be 2 or 3 or more conciliators. Remember, the more conciliators you appoint, the more money you pay. You can see another basket of agreements here, agreement on the number of conciliators. The next one is Article 4. Now that you've agreed on the number of conciliators you need, what you have to decide on the protocol of appointment. How do you appoint them? Now we say that if the parties agree on one conciliator, that means that they will jointly appoint the conciliator. If they have agreed on 2 conciliators, that means each of the parties appoints 1. If they've agreed on 3 conciliators, then each of the parties appoints 1, and the 3rd is jointly appointed. And that makes the 3rd conciliator. At that point, you're looking at a conciliation tribunal. The 3rd conciliator becomes the chairman of the tribunal because, strictly speaking, he or she is the only neutral party there. Because each of the parties would have appointed who they know. But the 3rd becomes the neutral party. He becomes the chairman of the tribunal. And when it's time if there's money to be paid to them, he gets a little more for his coordinating responsibilities. And when there is a tie in voting, he strikes, he casts the deciding votes. Article 5 talks about submission of statements. Now that the conciliators have been appointed, they need to know what the issues in dispute are. So the parties are to submit statements to them, to the conciliators, and they exchange the same statement among themselves to enable them to respond. Article 6 talks about representation and assistance, that the parties may be represented or assisted by persons of their choice. In terms of representation, we are talking about maybe due to ill health, one party may not be able to attend, or maybe he is not in town, or maybe anything could have prevented him or her from attending. Then he will now appoint either his lawyer, his spouse, child, anybody to represent him. But in doing so, you have to, like in writing, inform the conciliator and the other party that you will not be present, that you're sending so and so to represent you. And this is important because it's a confidential process. And then in the case of assistance, in case somebody may be an illiterate party, you may have an illiterate party, you may have some people that have disabilities one way or another, they will require some form of assistance. But even in that situation too, the other party has to be informed as well as the conciliator. Article 7, the role of the conciliator. The conciliator assists the parties in an independent and impartial manner in the attempt to reach an amicable settlement of their disputes. This is pretty straightforward. Article 8, administrative assistance. The parties or the conciliator with the consent of the parties may arrange for administrative assistance by a suitable institution or person. What can happen here? Sometimes you find yourself in a situation where parties request that the proceedings be recorded. Now, if that happens, I know that in arbitration, it is called verbatim recording. Yes, it is an outsourced process whereby the parties, on request from the parties, the arbitrator will get the services of verbatim reporters. And in that situation, it then means the process will be recorded, video, audio, and transcribed. Everything that happens, even when somebody coughs, it has to be recorded, video, audio, and transcribed. That is one way that an administrative assistance will be needed. Another area could be when you're dealing with a complex problem, a complex case, where it will be a bit challenging for you to coordinate the discussion and at the same time take notes. You may now have to get the services of some professionals that will sit in there with you to help you record the proceedings. Article 9 talks about communication between conciliator and the parties. The conciliator may invite or communicate with the parties orally or in writing. He may meet or communicate with the parties together or meet with them separately. The conciliator, after consultation with the parties, determines the venue of the conciliation, unless the parties have determined venue. I mean, you can see the kind of freedom or leeway or latitude that the conciliator enjoys. This one said he may meet with the parties together or with each of them separately. The mediator doesn't have those kind of privileges. The mediator mainly meets with the parties at the venue of the mediation. Separate meetings most times only transpires when, they go into private meeting after the plenary. They go, the mediator taking each of the parties to private discussions. That is while the mediation process is going on. But the conciliator can meet with the parties anywhere. He can meet them at the bar, can meet them at the hotel, he can meet them at any place and have discussion with them. Article 10 talks about the disclosure of information. Factual informations are exchanged between parties to facilitate response. However, specific information meant to be kept confidential are not disclosed, which means whatever you present to the conciliator, it has to be clearly marked, whether this is only for the conciliator only or to be passed on to the other party to enable them respond. Anyone that is marked confidential is kept with the conciliator and not to be disclosed to the other party. Article 11, cooperation of the parties with the conciliator. The parties will in good faith cooperate with the conciliator and comply with requests by the conciliator to submit written materials, provide evidence, and attend meetings, which means probably before now, the conciliator may have been doing his or her work based only on documentary evidence. And that's a major difference between mediation and conciliation. That the conciliator can go quite a distance in the process based only on documentary evidence. They will just ask for materials and they provide the materials.
Mr. Martins.
It is expected that parties.
Mr. Martins, may I request that you start rounding up? Mr. Martins, may I request that you start rounding up?
Okay, all right.
Thank you.
Suggestions by parties for settlement of this. Each party may, on its own initiative or at the invitation of the conciliator, submit to the conciliator suggestions for the settlement of the dispute. 13 talks about settlement agreements. A final settlement agreement follows in line with their inputs. That is after the parties may have made their observations on the suggestions made by the conciliator. If the parties reach an agreement on a settlement of the dispute, they draw up and sign a written settlement agreement. If requested by the parties, the conciliator draws up, and the parties, by signing the agreement, brings the process to an end. While Article 14 talks about confidentiality, everything about conciliation proceedings and the agreement is confidential, except for the purpose of implementation and enforcement. Article 15 talks about termination of conciliation proceedings. How do you terminate conciliation proceedings? By signing the settlement agreement. 2, by written declaration by the conciliator after consultation with the parties to the effect that conciliation efforts are no longer justified. 3, by written declaration of the parties addressed to the conciliator to the effect that conciliation proceedings are terminated. 4, by written declaration by a party to the other party and the conciliator, if appointed, which means this can happen before the appointment of the conciliator, to the effect that conciliation proceedings are terminated. 16, resort to arbitral tribunals, arbitral and other tribunals. The parties are saying here that, they will not initiate during the conciliation proceedings any arbitral or judicial proceedings in respect of a dispute that is subject to conciliation proceedings. So while the conciliation process is on, you stick to it. Okay, Article 17 and 18 talks about costs. The conciliator has to be paid and it has to be reasonable. And the reason, the criteria for payment includes the fees, travel and other expenses of the conciliator, travel and other expenses of the witnesses requested by the conciliator with the consent of the parties. Now, when you're talking about deposits, there are 2 scales of fees, the administrative fee and the conciliator's fee. The administrative fee has to do with logistics, to take care of logistics. So parties make equal deposits for the conciliator to spend. And at the end of the day, he gives an account of how he spent the money. 19 talks about role of conciliator in other proceedings. A conciliator cannot be invited as a witness in other proceedings. They cannot be appointed as an arbitrator or a representative or a counsel in any judicial or arbitral proceedings. Now, all the information gathered in an conciliation proceeding cannot be admissible in evidence in other proceedings. And that is a very key point in this process because it is a strong pillar that is holding this profession. Admissions made by the other party. You don't say, okay, yesterday this man agreed that he did this, he did that. You want to go and use it against him in court. It doesn't happen like that. Now, some of the advantages is that conciliation is quick, it's confidential. Conciliation, when satisfactorily conducted, enhances relationship. It is a flexible process that can be designed to suit parties' needs. Parties actively participate both in process and in decision-making. Participation is voluntary, except if it is enshrined in a contract agreement or demanded by law. The outcome of a conciliation process is always mutually beneficial to the parties. In conclusion, we say even in our practice as ombudsmen, there's really need to upgrade our skill set with the inclusion of alternative dispute resolution processes, as this will enhance the speed with which matters are satisfactorily resolved. One other area that ADR skills will assist us in our practice is in our approach to issues as ADR practitioners. It's in our approach to issues as ADR practitioners, and it's about enhancing our communication skills. Listening passionately to parties has a disarming effect and makes parties to be willing to listen to other people's views. There are some other strategies we need to deploy in our practice as ombudsman to make these are some of the strategies to make our practice as ombudsman more effective. Ultimately, the aim of conciliation is amicable resolution of disputes and the enhancement of relationship between parties. On this note, I just want to conclude by saying that conciliation works. It works, and we should all give it a try. Thank you very much for your kind attention.
Thank you so much, Mr. Martins, for that extensive presentation. Just to summarize what his presentation was about, it related to conciliation and that it's a non-binding process by an impartial third-party conciliator whose terms of reference he outlined and what is expected of them. He also highlighted the differences between conciliation and mediation, stating that conciliation is more of a formal process. He then explained in brief detail the 20 articles of the United Nations Commission on International Trade Law conciliation rules. He also spoke about the advantages of conciliation, stating that it's an expeditious, private, and a flexible process, among other things. He ended his presentation with an emphasis that ADR is an essential skill set that is relevant to the work of the Ombudsman. We will now move on to the question and answer session. We have quite a lot of questions that were asked, but however, if we are unable due to time to address all the questions, they will be put on the AOMA our website where they will be answered as well. The first question that we have, I will give a question for each panelist and they will respond, and then if time permitting, we'll go to a second round before we round up. I will request Mr. Ibeku, the first question is for you, which states as, what factors should one consider as the foundations to implement a strategy for successful mediation or negotiation in an organization? And then for Honorable Savino, the question is, how important is it to follow up with public bodies after a successful mediation to ensure that agreed actions are fully implemented? And what is the most effective way of follow-up? And then they're just wondering, as the Ombudsman of Santa Fe, do you have any written down procedures or policies that follow this? And then Mr. Martins, your question is, if there are merits in mediation or dispute resolution, why is there so many geopolitical tensions and workplace related chaos? So we will start with those questions. Mr. Ibeku, may I repeat the question, or you heard the question?
Kindly repeat the question, please.
Yes, your question says, what factors should one consider as the foundation to implement a strategy for successful mediation or negotiation in an organization?
All right. I'd like to bring to the fore an example, and maybe I will elucidate further. It's like a man during this COVID period, it's like a man that had a delayed rent, a man that was paying rent as and when due, but because of the COVID, couldn't meet that obligation. He had been paying rent for the past 5 years. And the landlord, because of an urgent need, forgot that this man had been a responsible tenant and wanted to pursue by all means in getting his money from that tenant, forgetting that the man had been paying his rent as and when due. So basically, what you should be looking forward as someone involved in negotiation, always look at what the outcome, what your interest is, why you want what you want, and how you're going to go about it. The man, if he had continued pursuing, if the man had made up his mind to continue pursuing his rights in these very, very funny times, of course, you and I know in the judicial system in Africa, he's going to be there forever. But if a man quickly says, okay, if I can dialogue with this particular person, this particular tenant, who had been paying me all this while, but for one reason or the other, he couldn't meet up with this obligation because of what we have seen present or what COVID had presented. Let me see how we can meet him halfway. Okay, the tenant says, okay, I'm going to just stay in your house for 3 months, and I'm that proposal. Are you hearing?
Yes, we're hearing. There was a bit of a glitch, okay. But we're hearing.
Okay, if he moves out in 3 months, your target as a landlord is, how am I going to recoup? And you could be lucky if you have a good agent or a good lawyer or a good solicitor, you could rent that property at a higher value. I was involved in that kind of transaction in this very particular time. A man was hell-bent on forgetting what the tenant had been doing for him all this while, paying his rent. Was that because of what the COVID problem was on board brought to him, he forgot their past relationship. And when the landlord finally bought into my suggestion, their house was rented out almost twice the value of the man who had only asked for 3 months to stay in that property. So as human beings, the foundation for us in this very, very key, wonderful facets of life called ADR mechanism, alternative dispute resolution, we should always look out what is the end result? How do you go about the end result? Be patient, we all have an open mind. Do not feel that you know everything. Like I stressed earlier when I was making my presentation, as a law student many, many years ago, almost 20 something or 30 years ago, we had a club lecture, and I've never forgotten, he said, even the devil does not know the intention of man. So you should not be fast to judge what the next person thinks. Allow the person to air out that opinion. Be patient. And as you're patient, be open. Be open to discussion. And I had earlier mentioned earlier that there is no better time for the practice of mediation than now. I want to extend that further to say for the practice of other conflict resolution mechanisms, because the world is faced with a lot of uncertainties. The world is faced with a lot of uncertainties. There's limited disposable funds. So you're not just going to be bent on, I must have a true litigation. And most of Africans, I'm sorry to say, most of the cases in court is just to show ego. I must tell him, I must teach him a lesson. But if you're open, you have an open mind of how to resolve your matter at a very pocket-friendly cost, then you've started a good race to ending your conflict. So you must have an open mind. You must be open to compromise. Open to compromise, have an open mind, and be willing to accommodate. Because eventually, like I tell everybody, even if you go to the courts and you have your judgment in your favor, the man that lost in the court will feel that he didn't have a good lawyer or that the judge was biased. But if you have a process as mediation and you people sit on the table, the man knows that, yes, you can imagine a community setup. If you have a matter in the community, we're all Africans here, or at least most of us are Africans. If you have a land dispute in the village and you and your brother resolve that matter, only being guided by an older person, and if both of you agree and you feel more fulfilled, there's a greater fulfillment that, yes, I participated in this decision that favored me, or that this decision that I had a say in. But when you go to the court, once you step into the court, even if it's your father or your mother, and you're stepping out of that courtroom, I'm a lawyer, I've been a lawyer for almost 20 years. So I'm not looking down at the law process, but I'm just telling you the reality. Once you step into the court and coming out of the courtroom, that relationship is smeared forever. It's never going to be the same. But if you have this opportunity to open your mind to create a good ground for how you're going to negotiate, how you're going to see the way to move out of a particular issue. For businessmen particularly, if you've been doing business for somebody for the past 20 years, and there's room for you to mediate or negotiate. So one of the advantages of mediation is basically the preservation of relationships. If you're involved in an oil gas sector, if you're involved in the oil gas sector, a huge financial cost sector, are you going to be going to the court every time over some breaches of contract? How much are you really going to spend? And this is a very technical area. And without due sense of humility, most of these judges are not so technically sound, no matter the amount of evidence that's provided. You need to have a hands-on knowledge on these things and find a way to know how to cut costs. And I mean, read these differences. And most times, most of us as human beings, the differences is just how you conceive what the next person has said. And incidentally, you might be saying the same thing with the person not knowing. So basically, back to your question is, have an open mind, be open to have a level of agreement. The man that agrees most times is not necessarily a weak man. I normally tell people that this practice of mediation, for us to manage to get parties to reach a settlement agreement, we must be unique as human beings, because this is a voluntary process. If somebody can sit under many sessions and get to a point of settlement agreement, then you must be a unique person as a mediator. Because this is anybody can walk out at any time. So it takes something extraordinary, unique in you as a human being, to get parties in a voluntary process to reach a settlement agreement. So basically, just for us to have an open mind, be willing to look forward to the future, not the past, and see how you can get this thing started up. Thank you very much.
Thank you very much, Mr. Ibeko. I think that is very clear that we need to keep an open mind and be willing to look forward and not backwards. Honorable Savino, I will move on to you to answer the next question, which is, how important is it to follow up with public bodies after a successful mediation to ensure that the agreed actions are fully implemented, and what is the most effective way of following up? And if you have, can you also share whether you have policies or procedures in relation to this? Thank you, sir.
Bueno, gracias por la pregunta. En realidad hablo desde la particularidad porque cada caso, cada acuerdo tiene sus particularidades. En primer lugar, nosotros como metodología es que cuando hay una mediación, se logra un acuerdo, se firma el acuerdo y alguna de las partes lo incumplen o no cumplen con lo acordado, tienen la posibilidad de volver al centro de mediación para replantear la situación, o bien, por el sistema que nosotros tenemos aquí en Argentina, en la provincia de Santa Fe, esa persona, si es un tema que no esté judicializado, va a la justicia, hace la denuncia y el juez automáticamente toma ese acuerdo de la Defensoría del Pueblo como caso juzgado, por así decir. Lo que se acordó es lo que se va a cumplir y el juez determina de acuerdo a lo que se firmó en el acuerdo de mediación. Esa es una metodología que se utiliza. Por otra parte, nosotros no hacemos seguimiento, salvo, como hablé anteriormente, en los procesos no de mediación, sino de restaurativo, justicia restaurativa, que tiene sí involucrado a menores, niños, niñas y adolescentes, que sí nosotros hacemos un seguimiento para el cumplimiento, porque casi siempre los menores, los acuerdos son a largo plazo, ahí sí, o desde la Defensoría del Pueblo, o desde la Defensoría de Niños y Adolescentes, hay una comisión que sigue cada uno de los casos para tener un cumplimiento, porque muchas veces involucra a empresas, por delitos, a empresas privadas, a organismos del Estado, a organizaciones no gubernamentales. Entonces, son dos sistemas distintos. El de la mediación o el acuerdo de la mediación viene o regresa a la parte afectada por el no cumplimiento del acuerdo, y eso sí tiene la posibilidad de ir a la justicia, y por otra parte, en todo lo que tenga que ver con los procesos restaurativos, sí hay un seguimiento. Si hablamos de los temas resueltos por facilitación, o sea, esos temas de menor cuantía, lo que se hace es, hay que ver si se firmó o no se firmó un acuerdo, porque muchas veces las partes se resuelven no necesariamente con la firma de un acuerdo. Esto que yo hablaba anteriormente, muchas veces las controversias se resuelven pidiendo disculpas o reconociendo algún hecho, digo, dependiendo del tenor del conflicto y el acuerdo firmado es la resolución final o cómo al final si se cumple o no se cumple, porque muchas veces nos llegan y otras veces no nos llega si se cumplió o no se cumplió el acuerdo.
Okay, thank you very much for that response. I'm noticing that we're well over our time. I will move on to Mr. Martins. And the question was, if there are any merits in mediation or dispute resolution, why are there so many geopolitical tensions and workplace-related chaos?
Yeah, thank you very much. In conflict analysis, there's something called PIN model, position, interest, and need. So when people agitate or when people protest or agitate over an issue, that could just be a way of calling the attention of government or people in authority to a particular need or interest that is not being attended to. The challenge we have, because basically, I mean, disagreements and people asking or protesting, asking for something or calling attention, it's not really bad. It's a way of life. In fact, if there's no disagreement in this world, the life will be so boring. But the issue here is that sometimes the people in authority do not provide the required platform for dialogue. All these agitations, both in my country, Nigeria, and other places, if you look at them closely, you see that they have one common denominator, and that is people in authority not paying attention to what the people are saying. Because we say that people's position is okay, they tell you what they don't mean and they mean what they don't say. But it's a way of calling your attention to their needs, to their interests. So basically, where there's so much chaos in Africa, in all over the world, including even the war in Ukraine and everything as it is happening currently, and the agitations we have in my country, Nigeria, is simply because that there are no platforms. The people in authority are not ready to listen. They're not ready to create platforms where people can come and sit down together and talk to each other like human beings and listen to each other. Yes, there are mediators who have in Nigeria, at least minimum, we should have close to 25,000 mediators. But the question is, why do we still have all these challenges? The thing is that the required platform, the willingness, the political will to do the right thing, to call these parties together and say, okay, fine, professionals, let's come and help us and do this. They are not doing it. Sometimes the politicians arrogate to themselves the right to know everything. They do everything and they assume they know everything. And sometimes they go in there and they mess it up. So agitations will continue except people are given listening ear. Except people, I mean, the people authority begin to accept, they start to feel the pulse of the people. They need to listen to people. They need to know what people are saying. They need to feel the pain of the people. In making policies, they need to consider people. Not running the government as if it's your, a personal property, or running it like a sole administrator. No, you are put there in trust to run the affairs of the nation on behalf of the people. So if the people are happy, then you're doing good as a government official. If the people are not happy, then you have to look at what you're doing again. So challenges, agitations, yes, they are part of life. They are not bad on their own, but it is how you address them. If you address them properly and professionally, all those agitations will even turn out to become like a source of strength, because diversity, there is strength in diversity. All those disagreements, whether it's gender, whether it is ethnic, language, religious, whatever, all they are asking for is a platform for dialogue. They want to be listened to. They want to air their story. They want to tell their story. They want people to give them a listening ear. They want their stories to be heard. And after that, when you give people listening ear, it is therapeutic. Once you give somebody undivided attention, when it is your turn to speak, you are likely to get a listening ear from that person. But when the people in authority feel that they are Lord and Master, they don't want to listen to anybody, that is when people now take violence as the only option available. Thank you.
Thank you so much for that response, Mr. Martins. We recognize that dialogue is very important, and for every party that is involved to be given an opportunity to be able to speak their mind. I will now request all the panelists. I think due to time, we are unable to answer more questions, but the questions will be directed to the panelists and shared with all the participants, and you can also check the AOMA and AORC website. So I will request each of the panelists to round up in about a minute, not more than 2 minutes, their final thoughts. I will start off with Mr. Ibeko, your final words. Thank you.
All right, thank you very much for having me. It's indeed a pleasure to speak amongst your own people, and of course, our friends across the continent. I'm indeed very pleased to have been invited. Like I'll say, as we all end the discussion, for us to have the mindset that there is no better time for the practice of mediation than now, and by extension, other conflict resolution mechanisms, because sooner than later, mark my word very strongly, mediation will no longer be an alternative. It will indeed be the main thrust. The world is faced with so many uncertainties that the best way to go about it is to resolve your matters, bring into the fore the advantages of mediation: confidentiality, preservation of relationships, cost effectiveness, and speedy resolution of matter. What more can one ask in a conflict resolution, if not these advantages? So thank you very much for having me. It was a wonderful experience being in this platform. I look forward to attending more. Thank you very much.
Thank you very much, Mr. Ibeku. We have people from all over, even Pakistan and Ireland as well, watching you. I'll hand over to Honorable Savino. May you please give us your remarks.
Bueno, en primer lugar, agradecer, bueno, Frankie, que estuvimos contactados. Como dijo mi colega, en realidad hoy las problemáticas son mucho más comunes en distintos, no importa que sean en África, en América, en Europa, en Asia, creo que tenemos problemáticas comunes y las metodologías son comunes para abordar el conflicto. El tema es qué compromiso asumimos como ciudadanos y ciudadanas, como funcionarios, como agentes, organizaciones no gubernamentales, qué compromisos tomamos en el orden social para recomponer el tejido social que ya tan destruido está a través de la pandemia, a través de las guerras, a través de todo lo que tiene que ver con conflictos sociales, culturales, económicos, ambientales. Hoy creo que el desafío es el de encontrarnos en este nuevo pacto social, donde los paradigmas son distintos, donde se está conformando un nuevo paradigma y donde tenemos que pensar totalmente distinto cómo abordamos de manera solidaria todas las conflictividades que tiene el comportamiento humano. Yo creo que agradecerles sinceramente que me den la oportunidad de participar, a disposición para lo que necesiten, desde mi humilde opinión, desde mi humilde saber. Uno está a disposición no solamente en nuestra provincia, en nuestro país, sino abierto para todo lo que necesiten los que han participado. Bueno, dejo a los organizadores todos los contactos y a disposición, no solamente mío, sino del personal de la Defensoría del Pueblo de la provincia de Santa Fe, de la República Argentina, a disposición. Muchísimas gracias.
Thank you very much, Honorable Savino. I will now request Mr. Martins for your final words, sir.
Thank you so much once again. And for me, all I can say is, as practicing ombudsman, it is of utmost necessity that we expand our skill sets and acquire especially ADR skills. After all, as administrative dispute resolvers and other dispute resolution experts, we don't have this enforcement, for now, enforcement powers. But when these disputes are properly resolved amicably, and parties feel that their input is taken into account, both the way you talk to them, the way you approach issues and everything, you see that at the end of the day, everybody is happy. Nobody will see himself holding the short end of the stick. Nobody will go home biting his fingers. You know, Ubeku said something. He said, look, you cannot come back from court and remain friends. And that is not the way for the ombudsman. I want to appreciate the fact that, having listened to these discussions today, that each and every one of us will go back and now take these processes very seriously and apply them to our job as we work and as we attend to people. And I can assure you that the rate of the result rate will be very high, because when people feel that they have been listened to, or their ego has been massaged, or when they feel that their emotions and feelings have been taken into consideration, then solutions will stick. So it is a good thing. It is a good day. I'm happy to be part of this. And I want to thank all the organizers, Frankie and his team, for having me. Thank you so much. Looking forward to having another opportunity to share experiences with you. Thank you so much. For those who may want my details, AOMA and Frankie and his team, they have my details. Thank you so much.
I'm so sorry, our facilitators lost connection. Let us take over from here and ask Marian to give a vote of thanks. Marian, please, you're welcome to give a vote of thanks.
Good morning, everybody. On behalf of the African Ombudsman Research Center, I would like to express our sincere gratitude to all esteemed panelists for their presence and contribution to making this webinar a great success. Sorry, I should have apologized at first. My camera is not working, so unfortunately, you cannot see me. I would like to say thank you especially to Mr. Adrian Bellinger, Dean and Head, Acting School of Law, on behalf of Professor Managay Reddy, who is the Deputy Vice Chancellor and Head, Acting College of Law and Management Studies of the University of KwaZulu-Natal. Mr. Adrian Bellinger conducted the welcome address. Thank you for conducting the welcome address on behalf of UKZN. I'd like to thank Advocate Koleka Galeka, Acting Public Protector of South Africa, who welcomed everybody on behalf of AOMA-AORC. I'd like to thank Mrs. Kurai Makumbi, Chief Human Rights Officer, Complaint Handling and Investigations, who facilitated on behalf of Honorable Elasto Mogwadi, Chairman of the Human Rights Commission of Zimbabwe. She did a sterling job facilitating the proceedings. I'd like to thank Mr. Chichioke Nana Ibeku, founder, principal partner of 3Cs, MET, International Institute of Mediation, Negotiation, Counseling and Conciliation, Nigeria, who discussed value and guidelines for interest-based negotiation in resolving disputes. Mr. Honorable Gabriel Savino, Ombudsman of Santa Fe, Argentina, who discussed the value and guidelines of mediation as a means of resolving disputes, as well as the work and tasks of the Ombudsman of Santa Fe's mediation unit. Mr. Chidi Bartons Lasprey, former Vice President in charge of Marketing and Membership Drive of the Institute of Chartered Mediators and Conciliators, ICMC Nigeria, who discussed value and guidelines for conciliation as a means of resolving disputes. Thank you for taking time out from your busy schedules to grace the event. To the presenters, I speak on behalf of the participants when I say your insightful and informative presentations are truly appreciated. This targeted training is what participants need in their daily operations. Thank you again for agreeing to present. Last but not least, thank you to all the participants. I would also like to thank the interpreters for always providing such a good service to AOMA. Thank you for the organizing team, especially Mrs. Hazel Langer from the UKZN Corporate Relations Office, who is always ready to assist in any way that she can. The upcoming webinars are reflected on the AOMA-AORC website. Feel free to register in advance by clicking on upcoming webinars to select the webinar you would like to attend and register. The dates for the next 3 webinars for 2023 and the topics are January the 31st, showcasing sexual ombudsman, children's banking and children's health and banking ombudsman. February the 14th, customer service skills, consistently delivering outstanding customer service, managing customer service expectations. March the 21st is research skills, especially web-based research skills. The official advert for each webinar will include details about the topic and information about speakers and facilitators. Thank you everyone once again for making this webinar a great success. Have a fantastic day further. Thank you everyone.
Thank you to everyone. And this is the end.